Congress now demanding answers on the Hunter Biden plea deal scam, the bizarre deal that the Biden DOJ concocted to try to curry favor for his son. It went in front of the judge, in front of Delaware. We saw she asked a couple simple questions. The whole scam deal went off the rails because it was insane. Hunter was essentially getting a prosecution immunity deal from the government for all sorts of other crimes where we know there's a lot of evidence that is mounting up. Congress is asking questions, and the judge wanted to know what happened. And when the judge asked questions, the DOJ didn't have good answers. Neither did the defense team, but Jordan wants to know more. How did this deal get crafted in the first place? Jim Jordan is the chairman of the Judiciary Committee, and he sent this letter over to Merrick Garland, the honorable, so-called Attorney General. He says, hey, Mayor, the Committee on the Judiciary, along with Ways and Means, Oversight, and Accountability, that's 3 committees now, are continuing their oversight of the executive branch, that's Biden's, and their commitment to the impartial justice. We're also investigating the veracity of statements made in response to our inquiries related to the DOJ investigation of Hunty. Given recent unusual events relating to the plea deal and to the pretrial diversion agreements, we write to better understand the DOJ's decision to sign off on this apparently atypical agreement. And this is so atypical, even the DOJ admitted that. The judge said, do you do this thing regularly? Do you have any precedent for this? No. Have you ever done this before? No. According to the court documents and recent news reports, Judge Mary Ellen Norica of the District of Delaware declined to accept the plea deal on Wednesday. The plea agreement relates to the tax charges that have been brought against Hunter, and the pretrial relates to the firearms charge. Judge Norica described the department's deal as, quote, not standard and, quote, different from what I normally see. She also raised substantial concerns with paragraph 14 of the diversion agreement. This means that if Hunter just doesn't get in trouble again and abides by the law, they will literally dismiss the firearm charge against him. So no felony conviction at all. Normally, if the department determines that a defendant has breached the pretrial diversion agreement, so Hunter's got to remain law-abiding and not, get in trouble, follow the terms of the diversion. But if he breaches, what happens? They say normally, if the department determines that a breach has occurred, the Department of Justice can unilaterally decide to bring charges against the person. You are given a get-out-of-jail-free card. It's kind of, hey, we're going to give you this opportunity to work away your crime. But if you commit a new crime, you're in big trouble. Not only are we going to charge you for the original crime, this is how it normally works, we'll also charge you for the new crime. But they didn't do that here. It does not require the district court's permission to bring the charges. It's the DOJ. They just do it. But as described by Judge Norica, paragraph 14 of this bizarre pretrial diversion agreement says that if the United States believes that a knowing breach of this agreement occurred, it may go back to the court, which is Judge Norica, and she can dictate that. This is the judge speaking. It goes on to say that if I do find a breach, then the government can either give the defendant time to remedy the breach, or they can prosecute him for the crime if it falls within the language of the agreement. And the judge is going, what? Thus, paragraph 14 of the diversion agreement means that unless Judge Norica makes a finding that it has been breached, no criminal charges can be pursued against Hunter. So it's like a speed bump in the prosecution. They want to take the decision away from the DOJ and give it to the courts, because the DOJ doesn't want to be able to bring the charges. Okay, they are like building walls off on their capabilities. Normally, they would just say, yeah, this is a new crime. I'm a prosecutor. I believe there's probable cause. I swear a complaint. There you go. Or it's an indictment. But they want to sort of cobble this and bring it back over to a judge in Delaware. At the hearing, Judge Norica asked the U.S. attorney, she said, excuse me, Leo Weiss, do you have any authority that any court has ever accepted that deal or said that they would do that? Has this ever happened ever in America in the history of the world? Prosecutor responded, no. Moreover, Judge Norica expressed concerns about the constitutionality of the provision. She says, well, now you make me a gatekeeper to criminal charges. You're kind of making me like a grand jury. Puts me in the middle of a decision as to whether to bring a charge or not. This is like basic constitutional separation of powers 101. She noted, she said, the government does not have discretion to continue to pursue charges or any other charge unless you include the court in this deal. And she says, that's getting outside of my lane in terms of what I'm allowed to do. I'm not a prosecutor. I'm not a grand jury. I don't confirm or swear a complaint. That's you. Judge Norica reiterated. She said, I asked if there's any precedent for this. I was told no. I was asked if there was any authority for this. I was told no. Congress continues. They say also, Paragraph 15 of the diversion deal says, this is the immunity provision. They say your pretrial diversion deal gives Hunter the following. It says the United States government, Daddy Biden's DOJ, agrees not to criminally prosecute Biden outside the terms of this agreement for any federal crimes encompassed in their big statement of facts, which was big and broad. Any crimes that's been attached. And they just said, well, Hunter was a crackhead for a long period of time. Anything involved with taxes or anything in that period is described in the statement of facts. Therefore, can't prosecute him. In a diversion deal that's going to ultimately dismiss the felony charge, says this grants immunity in the pretrial diversion agreement. Therefore, it not only covers the gun-related conduct, it also covers entirely unrelated conduct covered by the plea agreement. It's nuts. It's just like if you just walked into a candy store and they're like, this is all yours, take whatever you want. Judge doesn't care. That's what they're doing. During the hearing, Judge Norica questioned the department about this apparently unusual provision, asking whether the U.S. attorney, quote, had any precedent for agreeing not to prosecute crimes that have nothing to do with the case or the charges being diverted. Have you ever done this before? Like where somebody's being charged with shoplifting and you say they're also immune for murder? They stole a candy bar and you're saying, well, they murdered a few people too, but they're exonerated for the murders because they stole the candy bar. Do you have any precedent for agreeing not to prosecute crimes that have nothing to do with this? He said, I'm not aware of any, Your Honor. No, I don't. The judge followed it up. Have you ever seen a diversion agreement where the agreement not to prosecute is so broad that it encompasses crimes in a different case? U.S. attorney says no. Don't have a good answer on that one either. Now, taken individually, each of the provisions raises serious concerns about how the DOJ handled this. But when considered together, the provisions appear to be even more troubling. Judge Norica explained the problem. What's funny to me is that you put me right smack in the middle of the diversion agreement that I should have no role in. You plot me right in there. And then on the thing that I would normally have the ability to sign off on or look at in the context of the plea, you just take it out and you say, Your Honor, don't pay any attention to that provision not to prosecute because we put it in an agreement that's beyond your ability. This was also insulting. They drafted this plea under the rules that said that the judge doesn't have any authority to really reject the plea. But they wanted the judge simultaneously to be the arbiter of problems that happen under the plea. She said, what are you asking me for here? In short, the department shifted a broad immunity provision, which benefits Hunter, from the plea to the pretrial diversion agreement to stop the judge from being able to scrutinize and reject it. Because the immunity deal is in the diversion agreement, and the diversion agreement is the agreement between Hunter and the government. The plea is the agreement between the government, the Hunter, and the judge. But the diversion, because they're ultimately going to dismiss the charges, they don't even need to file the charges. They can just stop the prosecution. It's putting the prosecution on hold or on a delay while the diversion can be completed. If the diversion is not completed, they will reinstitute the prosecution. If it is completed, they turn around and file a motion to dismiss the case. And then the department has also benefited Mr. Biden by giving up its unilateral ability to bring charges. So now they say if Hunter commits a new crime, the DOJ doesn't have the authority to bring the charges on their own. They've got to go back through the courts. And I think part of the reason they did this, or they wanted this in here, is to say that if, let's say, Trump wins, his DOJ takes over, his people say, well, we think your plea deal was a problem or you breached because of this, and we want to bring in new charges based on the fact that you violated your diversion deal. This would give them a failsafe. It would take it away from an adverse DOJ and give it to the court. Instead, it placed upon itself the burden of getting the district court's permission to bring the charges, even though they normally have no role in policing these agreements. So the district court apparently is removed from the equation when it hurts Mr. Biden and inserted when it helps Mr. Biden. I don't know. I could be reading that wrong. Anyways, status of the ongoing investigation says the committees are also concerned that, contrary to its representations to the Judiciary Committee, the judge may be claiming that other investigations into Mr. Biden are ongoing to shield the department from oversight. In that regard, it was notable that Mr. Biden's counsel stated at the hearing that it was his understanding that the immunity provision in the pretrial diversion agreement would preclude the department. Right, so this was Hunter changing his understanding like in real time. He came out, the judge said, Hunter, would you take this deal if you didn't have immunity? He said, no, of course not. Then they went behind closed doors. Nothing changed in the deal. And he came back out and he said, yes, I'll take this deal now. Why? Because it was an unwritten deal. Yes, the immunity deal may not have been included to his satisfaction, but He got an unwritten promise from the DOJ. We're not bringing charges. While the department did not agree with that position, it's difficult to understand how the parties would not have a meeting of the minds regarding a clause like this that's so fundamental. It raises questions about the discussions that have been taking place between the DOJ and Mr. Biden's counsel. So here's what they want. Congress has a lot of questions. They say the department's unusual plea and pretrial diversion agreements with Mr. Biden raise serious concerns, especially when combined with recent whistleblower allegations from Gary Shapley, Joseph Ziegler, Gal Luft, and others, that the department has provided preferential treatment toward Mr. Biden in the course of its investigation. We have the following questions. Other than Mr. Biden's case, Merrick, how many times in the last 10 years has the DOJ for Delaware included a pretrial diversion agreement like paragraph 14? I'm guessing 0. What percentage of the total pretrial diversion agreements entered by the District of Delaware does that number represent? What is that number as a percentage of all of your pretrial diversion agreements? Is it 5% of them? Is it 10% of them? Is it 1%? Is it 0.0001%? What is it? Other than Hunter's case, how many times in the last 10 years has any unit of the department included a provision like paragraph 14? Any unit of the department. So Delaware, but now any unit of the department. How about the same question with the pretrial diversion agreement and diversion for gun charges? So they're doing the old compare and contrast. Do you have an agreement not to prosecute crimes that are unrelated to the diverted crimes? How many times do you grant diversion for shoplifting but excuse people for murder? What percentage of that does it represent? Did the U.S. Attorney's Office for Delaware or Biden's attorneys suggest paragraph 14? Who put that in there? You or Hunter's people? And who asked for permission to bring charges through the court? You or Hunter? Same question. Who put the pretrial diversion immunity deal in there? And they say all of this is to advance our oversight. Remember, we need a legislative purpose to conduct these inquiries. We're considering legislative reforms. So we want the following: a list of similar pretrial diversion agreements entered into by the department for felony firearms possession charges, all documents and communications related to similar diversion deals in the last 10 years for felony firearms, a list of pretrial diversions with paragraph 14 similar with Hunter, same list with unrelated charges being diverted, a generalized description of the investigation, and an explanation from Merrick Garland why the department originally agreed to a plea agreement if there are other open investigations that are ongoing. Please provide this information to the committee no later than 5 p.m. August 14th. As you know, the Judiciary Committee has jurisdiction over this, including criminal justice matters, and we look forward to your prompt attention to this matter. Sincerely, your friends, Jim Jordan, James Comer, and Jason Smith. So we'll see what Merrick Garland says in response to that. But the corruption runs deep. Marjorie Taylor Greene posted this thread that makes some very serious connections. Says Devon Archer, Hunter Biden's former best friend and business associate, asked why he was being arrested and investigated. Devon Archer is going to be going to prison. Hunter Biden is not. Devon Archer has a self-surrender date. Hunter Biden has another court date where they're still going to try to work out a plea deal. Well, he'll be able to escape any criminality. But there were some very curious text messages that have been popped up. Marjorie posted this one. She said, this is an interesting conversation between Devon Archer and Hunter Biden. Hunter Biden's on the right. He's asking for some money here. This is March 4th, 2019. He says, have you seen Cash App? Try using my code. We'll both get $5. He says, any luck, buddy? Did you get your Cash App going? Hunter saying to Devon. Devon says, I don't have a bank account. I can't do Cash App. Okay, buddy, how did we do last time? If it's an issue, no problem. We're going skiing today and just wanted some cash for lunch. Hope the Eudora money will hit today. Sorry to ask. Hunter needs lunch money from Devon Archer. Guy was making millions a year. Needs lunch money. He says the place is next to Wachusett. Have you been there before? It's a cool little mountain. Devon responds. He says, why did your dad's administration appointees arrest me and try to put me in jail? Just curious. Some of our partners are asking out here. Why would they try and ruin my family and destroy my kids? And no one from your family's side stepped in and at least try to help me. I don't get it. And I'm depressed. Bunch of these, pejorative word, the way he uses it, getting in my head, asking me the same. So just curious what I should answer. And Hunter responds. He sends this March 6, 2019. Buddy, are you serious? Because there's no connection or control between the two. The same Justice Department can investigate and prosecute this president and his family. It does for all administrations. Trump's in office right now. It's democracy. 3 co-equal branches of government. You are always more vulnerable to the overreach of one of those co-equal branches when you are in power. Every president's family is held to a higher standard, is a target. It's the price of being the most powerful group of people in the world. Hunter talking. It's why our democracy remains viable. It's unfair at times, but in the end, the system of justice usually works like we are redeemed and the truth prevails. The unfairness to us allows for the greater good. Devon says, I'm depressed. I love you anyways. Everyone other than you sucks, though, including them all. And your brother was with me. Yes, he was, and I always am. So he must be talking about maybe Bo, like Bo is with him spiritually. Yes, he was, and I am always am, and turn the discussions around, Devon. Every great family is prosecuted in the U.S. You are part of a great family, not a sideshow, not deserted by them, even in your darkest moments. That's the way Bidens are different, and you are a Biden. It's the price of power. And the people questioning you truly have none, whereas you do through perseverance and poise. Love you, bro, says Devon. Sorry. Long way from home from a couple weeks and the demons are talking to me. Curious exchange here. And you see that Hunter considers himself to be part of the most powerful family in the world. Sounds like he's talking to somebody who he is willing to expend. Do you really think that Hunter and Joe Biden consider Devon Archer to be a Biden? Or would they throw him to the wolves the first chance they get? You would imagine it's the latter. But you can see how they talk to people, how they exploit people, and how they lie to all of us. Fortunately, Congress is asking questions about it. Jim Jordan and others now demanding answers about the scam plea deal that was concocted for Hunter, for Joe, for this entire scam. There will be much more on this, and we'll be here to cover it.